Good morning. Sorry we don't have better weather today, but it is Cleveland and it is November. My name is Jonathan Adler. On behalf of the law school, on behalf of the Center for Business Law and Regulation, and on behalf of the Law Review, would like to welcome you to this year's LEAD Symposium, which is co-sponsored by the Case Western Reserve Law Review, which will be publishing the proceedings from this conference. The LEAD Symposium was made possible by a generous gift from George Leet, who made in 1999, who was a 1946 graduate of the law school, who spent his career at the National Labor Relations Board, and apparently was successful enough as a long-time career labor attorney there that he wanted to endow this program on business law. And we are certainly very grateful to his generosity and the support it continues to provide for programs like this. This is one of many programs that the Center puts on related to questions of business law and regulation. Certainly, if you're interested in other programs, certainly check out the website that lists programs that we've recently sponsored, such as recent lectures by Judge Joan Larson and Judge Jeff Sutton on issues on the relation of federal and state law. But you didn't come here to listen to me. You came here to listen to people that know far more than I do on questions of corporate law and business law. So I'm going to turn things over to my colleague Stephen Wilkes, who will introduce and moderate the first panel. Again, thank you for coming, and a special thank you to the Law Review for all the work that they've put into making this conference possible, to my colleagues Professor Enton and Professor Korsmo and Professor Robertson, who worked very hard on this program, and certainly to Eileen and Patty outside, who have been working tirelessly to make this possible. So thank you all for being here, and I look forward to an exciting and interesting day on important questions of corporate law. Thank you.
Good morning, everyone. Again, my name is Stephen Wilkes, and I am delighted to be here today and to assist in the moderating of this panel. We've got three wonderful colleagues who are here to participate in what I hope will be a fruitful and searching discussion about board composition. When I was invited to moderate this panel, I kept thinking back to the days of Enron and the discussion about board composition that flared up at the time, given sort of the context of that scandal. And a lot of the discussion at the time had to do with, the experts on the board, what kinds of expertise should we expect of our board members so that they can give effect to their fiduciary obligations with the corporations they're serving. And so we're back, interestingly, we're now back at that place yet again for a variety of reasons. We are in a legal, economic, political, regulatory climate where I think the corporations and their boards are being asked to think of all kinds of things in the shaping and deliberations of the corporate decision-making and corporate praxis. And so with that in mind, I'm really pleased to sort of introduce you to three colleagues. Immediately to my right, we have Todd Henderson from the University of Chicago Law School. Next to him, we have Ann Lipton from Tulane Law School, and at the other end of the panel, we have Sean Griffith from Fordham. And so the way this is going to work is we are going to have 15 minutes discussion time from each of our panelists. I believe we have someone at the front of in the well of the room here who will alert us when we're at our 5-minute mark, because of course no one ever goes over time. And then once that's done, I'll sort of insert myself into some of the discussions and invite you to answer some questions. And then I think we've got some mics, and we'll invite members, the rest of you, to sort of jump in and with questions. I think we've got a total of 75 minutes for today's time, and so at some point we'll have to cut that off and make time for other panels that are taking place throughout the day. So I'll start with Todd, and we'll go from there.
Thank you. Thanks to the Law Review and to Case for inviting me. It's a pleasure to be here. So I'm delighted that you led off with Enron. Right before Enron's collapse, they were widely regarded as the best governed firm in the United States. It's been 5 years running that their board had gotten the gold seal of approval from various people who rate these kinds of things. I'm going to call them experts, although as you'll see in a second, there's no such thing. And then, of course, Enron famously collapsed. And it wasn't just that they collapsed because they made some bad judgments about this product or this financing or that financing. They collapsed because, in part, people within the executive arms were engaging in massive risk-taking and stealing that the board knew nothing about. So it was, among other things, a governance failure, a complete governance failure. Boards matter a huge amount. This is the way, as all the people in law review probably know who took business associations, the board is the entree point through which law tries to affect how companies are governed. All the Delaware cases are about board members and fiduciary duties. Sure, officers have them, but in the typical case, which Sean's going to talk about and Anna's I think going to talk about, board members play a very important role, and a lot of the case law about caremark duties and fiduciary duties and other things, these are all really board level questions. So boards matter a huge amount. Governance matters a huge amount. There's lots of economic literature about the importance of governance and how governance quality is highly associated with economic success. There's a great economist at Stanford who has sort of crunched the numbers and looked at governance of firms across the world, finding American companies are the best, most well-governed firms, and this is highly correlated with them being the most successful generally. The problem is that we have no idea what good corporate governance is. The reason is, and it's staggering to think, that the metric for good corporate governance is what some experts opine and think it is, because that's not really worth anything. There's no rigorous market for disciplining experts. I could get up here and make all kinds of prognostications about how great this board or this governance approach is. You should stagger boards. You should de-stagger boards. You should add women. You should subtract women. I could make all kinds of claims that these things would make firms better, and of course then walk away and still have my tenured chair at Chicago and go on talking about this, and there would be no way of disciplining my prognostications. This is also true of people who work at ISS and everybody else that's in this business. We have no way of measuring corporate governance because there is no market for corporate governance. We have businesses performing in the real economy, and their performance, operational performance, is impossible to separate from corporate governance. So you'd have a firm that's doing really well, and humans would just logically say, if that firm is doing really well, it must be because it's well governed. Why? Maybe it's horribly governed. It's doing really well because somebody had a genius idea about a phone or a microchip or a sports drink, and that's what's making it do really well, and it would be doing even better with less risk if it was well governed. Similarly, there could be a company that is doing terribly because its product designers aren't doing a very good job, its ad people aren't as creative as they should be, and yet it's incredibly well governed. So point one I want you to take away, we have no idea. And anybody who says they have any idea is selling you a bill of goods. Okay. A sub-point of this is there's a vast scholarship about corporate governance and firm performance. I'm going to tell you that all of it is crap. All of it. You shouldn't believe any of it. And the reason is that the economists and lawyers who do this have taken these metrics like Tobin's Q is a very famous one. Tobin's Q is the output that these scholars use to measure whether a firm is a good firm or a bad firm. It's the sort of standard in the industry. And what is Tobin's Q? Tobin's Q is the ratio of the market value of the company's assets to the book value of those assets. You paid a certain amount for something, $100. What can you turn that into? If you turn it into $1,000, your Tobin's Q is 10. If you turn it to $10,000, your Tobin's Q is 100. You're doing better. Okay. Unfortunately, and there's a pretty growing literature on this subject, this is a really bad way of measuring firm value because lots of stuff aren't in book value. There's this ratio was not invented as a metric for measuring firm performance. It was a management tool. There's a whole problem with this Tobin's Q that's pretty well documented now. There's probably 50 papers in the last year. And everybody uses this Tobin's Q. Just to give one example, intangible assets are not in book value. So a firm with lots of intangible assets is going to have a lot higher Tobin's Q for no other reason than the accountants tell us that we don't measure these things in book value. Okay, so when someone says to you, if you de-stagger your board, you will create firm value because these firms have higher Tobin's Q, you should just stop right there and say, I don't believe you. These studies have other problems. Largely, they look at industry-wide results. And so you might say, across all these firms, let's accept the fact that it would be true that staggered boards are associated with higher valued firms. These studies pretty much discount the possibility of local maxima. It might be the case that for a particular firm, de-staggering its board would destroy firm value, even if for every firm, on average, it would be better to have a staggered board or de-staggered board. Because I tend to believe that firms are pretty good at maximizing firms, their own local conditions. It may be true that for all firms, having a board of a particular size or de-staggering the board would, on average, if you don't know what kind of firm you are, that would be a better choice. But firms adapt to local conditions. Okay, so I don't think we know much about corporate governance, and I don't think you should believe any of the studies that say, I can show you mathematically that this is the way this company should be governed. There are gaps in corporate governance at the board level. I've written a book about this, and in the book we mentioned some staggering statistics. McKinsey & Company in 2016 surveyed 5,000 directors. That one of the questions they asked them was, do you understand the strategy of your company? 34% of board members agreed with that statement, that they understood the strategy of their company. 34%. These are board members self-reporting that they are ignorant about the strategies of their boards. This is a staggering statistic. The typical board member today, and I should say, I don't want to be too pessimistic, board quality has gone up. There's been a renewed emphasis, part of it by virtue of law. So I think board quality has risen. But it's pretty remarkable that board members are that uninformed. Moreover, the typical board, our typical insight into boards about how well they're doing is pretty opaque. If you're a shareholder of Apple Computer, you will know how many board members there are. You'll know where they went to college and grad school if they did. You'll know how old they are, a little bit of their bio. You'll know how much they're paid in stock. And if you follow ISS, the proxy advisors, you'll know whether or not that board member showed up at 75% of the board meetings or not. That's it. You'll know nothing else. You won't know whether they slept during the meetings, whether they do the reading material, whether they participate in the board meetings, how they voted, what the vote on a particular issue was. There is zero transparency from shareholders into this black box that is the corporate boardroom. That just can't be right. It can't be right that shareholders have no idea how much they're spending on corporate governance, what the metrics are for good corporate governance, whether or not, how someone got on a board of directors. I've interviewed for only 2 board positions and not gotten on either one of them. And how did this interview happen? Well, I knew a guy who knew a guy that went to Princeton with a guy, and then I had a conversation with the CEO. What? Now, the CEO used good judgment in not having me on the board, but that's kind of staggering. Okay, so in my last 2-3 minutes here, having set up the fact that I think corporate governance is hugely important, but yet it's this big black hole. We know nothing about it. You hear people say, oh, we should add more minorities and women because we need diversity of opinions in the boardroom. And here's this study. Companies that have women on their boards are worth more. No, this is crazy talk. I don't know if it's true or not true, but this study doesn't say it's true. That's like saying that I have more books in my house, and so my kids are smarter. These are correlated, but they're not caused by the thing. The fact that I have books in my house means that I am a smart person, allegedly, and I'm passing that on to my kids, not through the books. My kids I've never seen my children read a book. Drinking red wine does not make you live longer. Until we randomly assign people into red wine and non-red wine, we have no idea whether red wine is correlated with living longer or whether it's the fact that people who drink red wine who also exercise more, and it's exercise or something else. Okay, so what should we do about this state of affairs? Well, Steve Bainbridge and I have a book in which we say we need to create a market for corporate governance, and the way to do that is to change one small provision of Delaware law. That provision of Delaware law requires board members to be individuals. Delaware requires board members to be natural persons. That means when Boeing is hiring its board and hiring corporate governance services, it has to hire 12 or 15 sole proprietors. It has to hire Todd, who has to deliver corporate governance as a sole proprietor, as an individual. I'm not allowed to form a firm. I'm not allowed to form an association of directors to provide these governance services. When Boeing needs accounting services, they hire an accounting firm. When they need legal services, they hire a law firm. When they need consulting services, they hire a consulting firm. But governance, they've got to hire individuals. I think this is wrong, and we should change it. At least let companies experiment in hiring governance firms. Instead of hiring Todd and Ann and Sean, they'd hire a board company. Boards Are Us. And Boards Are Us would provide the board services. That firm would have all the advantages that firms have in other parts of the economy, but then also there would be a very robust market for corporate governance. Instead of the CEO interviewing me for the board position, one position, instead of somebody launching a proxy contest, we would have board firms competing with each other to provide corporate governance to other firms. I'm not saying all firms should do this. I'm just saying that firms should be allowed to experiment with having corporate governance provided by a market, and the market would bring transparency and discipline and a kind of reinvigoration of corporate governance. Then we might be able to make some progress on what is good corporate governance, what is bad corporate governance, because until we do that in some systematic way, I think a lot of the talk about corporate governance is just window dressing and posturing. And on that, I'll stop.
Wonderful, thank you. Anne, you are currently working on an article, I understand, titled Shareholder Primacy, Maximize What?
Yeah.
And I think this is really interesting. Is that sort of aligned with your presentation today?
Yeah, that's my presentation, which is only, sort of somewhat intersects with the actual topic of this panel. But anyway, what I am going to talk about is what we mean when we say shareholder primacy. And I'll start by saying I'm basically talking about Delaware law and federal law, even though I know some states do things a little differently. And I'm going to begin with a story. And the story is the story of the PLX case, which was actually just decided in Delaware a couple of weeks ago, a post-trial opinion by Vice Chancellor Laster. It'll probably be appealed, so this opinion is probably not the final word, but it really just encapsulates the issue. So in this case, an activist hedge fund known as Potomac targeted a company called PLX. And Potomac's theory was that PLX should immediately find a buyer and sell itself right away. And management didn't want to because it thought that it had a better plan for long-term value, that if it tried to sell right away, it would be a fire sale. They would undersell the company. So Potomac launched a proxy contest. They wanted a short slate of candidates. They wanted to put 3 candidates on a board of 8. And their entire campaign to the other shareholders was sell right away. And the management, no, don't sell right away. You will do better if we stay the course, long-term value creation. Potomac won the proxy contest. The shareholders put Potomac's nominees on the board. And at that point, the board basically gave up and agreed to sell the company. Now, at that point, a lot of weird things went on in the sales process, which are the subject of his opinion, of Vice Chancellor Laster's opinion. It all ended up in a shareholder lawsuit claiming that there was a breach of fiduciary duty at the board level. Vice Chancellor Laster agreed there was such a breach, particularly by the Potomac nominees, those 3 Potomac people who were on the board. And critical to his conclusion that there had been a breach of fiduciary duty was his conclusion that those board members were conflicted. And the reason they were conflicted is because they had interests that diverged from those of the other stockholders. And what were these interests? They had a short-term outlook because their hedge fund needed to make a quick profit. And as a result, their interests diverged from the interests of the other stockholders who would have benefited from long-term value creation. Now, this is extraordinary because there was a vote. There was a shareholder vote on this precise issue. And the shareholders said, we don't want the long-term value creation. We want the short-term sale. But rather than even mention this, he relates that in the standard of facts, in the statement of facts, but rather than even mention this in his analysis, he just concludes these board members, their interests diverged from the interests of the stockholders because they wanted a short-term sale instead of long-term value creation. So, what Laster, what the actual shareholders actually wanted, which was this quick sale, didn't even come into the question. He concluded basically that the directors' obligations was for long-term wealth maximization, and what the actual shareholders actually said that they actually wanted wasn't going to be on the table. So the question I pose, is that right? And when I say is that right, I mean is that right as an actual statement of the law as it exists today? Was Vice Chancellor Laster correct? But also, is that really the rule that we want, even if it is a correct statement of law? So when we say that a corporation is run for the benefit of the stockholders, what does that mean exactly? There are 2 interpretations. One is it's run for wealth maximization and probably long-term wealth maximization. But the other interpretation is the board is run to follow, the corporation should be run to follow the shareholder priorities. If the actual preferences of the actual shareholders are something other than wealth maximization or long-term wealth maximization, then directors have a duty to do that. Now, it's only recently that this has even become an issue because for a very long time, at least in publicly traded corporations, the shareholders were dispersed. They were retail shareholders. They didn't really have a way of making their preferences known. So we could just assume they wanted long-term wealth maximization because we didn't really have any other information about it. But that's not the world we live in today. Today, even the largest corporations have powerful institutional shareholders, and they hold significant blocks of stock, and they can collectively make their desires known. And that means it's now the question we have to ask, whether directors honor the actual stockholders or whether they honor this idea of long-term wealth maximization. So the first thing we ask is, why would shareholders want anything other than long-term wealth maximization? And the first answer is obviously because maybe they want short-term wealth maximization, as in the PLX case. Although that's actually kind of funny because after Vice Chancellor Laster went through all this, he then refused to award the plaintiffs any damages because he concluded that there was no long-term wealth maximization to be had. The price, in fact, was right, and it was not going to get any better than the merger price. So as it turned out, everybody they were right to want the short-term because there wasn't a long-term. But anyway. But assuming there is a difference between long-term and short-term, one thing that might happen is shareholders prefer the short-term. So that's one reason why shareholders may differ from this long-term wealth maximization ideal. Another reason, socially responsible investing. Certainly there's a whole argument that socially responsible investing is actually beneficial to the company, that you make money by doing good. And that's probably true, at least on some dimensions, but it's also probably not true on a lot of other dimensions. There are shareholders who just don't either want to be invested in a company that they think is unethical, they don't want to contribute capital to something like guns or a company that's going to pollute the environment, even if it would be better for the company. So that's a reason why shareholders may not want wealth maximization. There are certain lines that they would prefer the company just not cross as a moral matter. No one's saying that these shareholders don't want to profit. They're just saying that they're willing to share some of the profits. They're willing to sacrifice some degree of returns, how much, is up for debate, in order to do good. But altruism is not the only reason shareholders may want something other than wealth maximization. They may not want wealth maximization because they aren't just investors. They're employees, they're residents of the community, and they feel they can benefit more in their non-investor capacities if the company does not maximize wealth. So, for example, labor unions. They invest to provide retirement benefits to their members. Corporate employees often have stock, they have stock options, and these workers may value their salaries and their working conditions and their medical benefits more than complete wealth maximization in the stock. So given a choice, they would rather the company devote more resources to making employees better off than purely maximizing the value of the company. And we might have investors with broad portfolios. Their goal is to maximize the portfolio as a whole rather than to maximize any one particular company. And so one issue that's gotten a lot of attention recently is this idea of horizontal shareholding. When you own a fund and that fund owns stock in a bunch of competing companies, Delta, JetBlue, Southwest, all of that. They may feel that it is better that these companies not compete with each other too vigorously because that maximizes wealth across the portfolio, even if it doesn't maximize wealth in a particular company. So Delta can do better if it really competes with Southwest, but Delta and Southwest together do better if they don't compete with each other. So a shareholder who owns that kind of portfolio may not want to see wealth maximization. Or what if they own both stock and debt in a company? They may not want to see pure stock price maximization because it hurts the debt. Or if they own stock in both the target and an acquirer in a merger, they may rather balance between the two rather than see both companies try to maximize their wealth. So there are real reasons why shareholders might prefer something other than wealth maximization at a particular company. And we have to ask, what are the directors' duties in that situation? And when we ask this question, we can say that whatever their duties are, whether it's wealth maximization or obedience, it's only going to come up if there's a dispute, because there's no regulator that steps in and says and tells the directors you're not maximizing wealth appropriately. So we have to assume that the shareholders are not going to be unanimous on this. And which means, for the purpose of this exercise, we have to assume it's probably not a closely held company. I mean, there can be disputes in closely held companies, there certainly are. But I mean, in a public company, there will certainly not be agreement among all shareholders about what the best course of action is. Now, also, as we all know, because of the business judgment rule and because of demand requirements and derivative actions, it's very unlikely that this kind of thing is going to really come up in litigation very much. I mean, PLX notwithstanding. So it's not a question of whether directors are going to be sued, but what we answer to this question really has a lot of implications for how we want to structure corporate law in general. So what does the existing law say? We find that Delaware, for example, has been sending a lot of mixed messages. On the one hand, Delaware courts, there's lots of case law, older case law, that says that a director's duties are to maximize wealth and not to cater to the whims of the stockholders. So this is why, for example, directors are allowed to maintain a poison pill in the face of a hostile tender offer. Even if the shareholders want to accept the offer, directors can say no. Chief Justice Strine put it in one case, and this is from back when he was on the Chancery Court: directors are not thermometers existing to register the ever-changing sentiments of stockholders. Directors may take good faith actions they believe will benefit stockholders, even if they realize the stockholders don't agree with them. On the other hand, we have this new line of cases, the Corwin line, which basically allows shareholders to ratify even fairly egregious what would otherwise be breaches of fiduciary duties if they vote in favor of certain actions that directors take. That line of case law suggests that as long as the shareholders, by a majority, not a unanimous vote, agree to whatever the director's course of action was, it's going to be okay, even if that was not a wealth-maximizing course of action. So that's state law. What about federal law? Look, once again, the law is a bit conflicted. So the federal securities laws have this idea of materiality. Companies have to disclose information that's material to investors. And the actual definition of materiality is just how what would be have an effect on a stockholder's vote. But the SEC, and that doesn't have to mean financial or wealth maximizing, it's just if a shareholder would consider it when voting, it's material, or buying or selling. But the SEC has recently reinterpreted that standard to mean from a financial point of view, if it would affect a stockholder's decision financially. That suggests that the SEC is guiding towards a kind of wealth maximization idea. And there are other ways that the SEC has gone sort of back and forth on this. And the SEC has also been taking a lot of steps to give the shareholders more power in the governance structure, which suggests that companies are going to have to bow to shareholder influences. It's loosened the proxy rules. Dodd-Frank gives shareholders say on pay, all of which suggests moving more towards obedience to what shareholders want rather than a wealth maximization norm. So the law is muddled, both at the federal level and at the state level, which brings me to the question, is this a good thing or a bad thing? If shareholders want something other than wealth maximization, non-unanimously, should the legal system honor that preference? One argument is wealth maximization should absolutely rule because we can assume that all shareholders invest to make money, and therefore the sort of least common denominator is wealth maximization, so that's what everyone agrees on, so that's what they should do. And usually that's some kind of argument about a hypothetical bargain. If shareholders were actually bargaining for what they would want, they would all agree, let's put our petty differences aside and at least agree on wealth maximization. But that's hypothetical. That may not be, in fact, what they would bargain for, especially if they think wealth maximization hurts their interests. So, for example, labor unions now, when they can bargain in the private equity contest, not public companies, more and more they're insisting that private equity firms protect workers when they do their buyouts, which suggests that, in fact, when shareholders have the opportunity to bargain, they will bargain for something other than pure wealth maximization for the equity holders. On the other hand, if we say it's okay for directors to bow to shareholders' actual interests, now we have to deal with the problem of majorities that exploit the minority. What if there's a controlling shareholder? That's a majority of the votes. Do they get to just exploit the minority? So we have to define, and traditionally the solution to that was to say we will only pay attention to the votes of the disinterested shareholders. We would say if a shareholder is conflicted, we won't count them, and then the majority of what the disinterested shareholders want will control. But if we start from this premise that shareholders have a lot of interests other than wealth maximization at a particular company, none of them are really disinterested. And this is actually a box that Delaware has found itself in now that it's given more power to shareholder ratification, trying to define what counts as a disinterested shareholder. If there's a merger vote and BlackRock owns share in both the acquirer and the target, is BlackRock disinterested? Delaware doesn't have an answer. Nobody has an answer. So if we're going to start to bow more to shareholders' actual desires, we have to have a better understanding or a better way of dealing with these conflicts of interest among shareholders and what counts as sort of a legitimate, well, you just lost kind of a conflict versus an actual exploitation of the minority. And how we're going to deal with that is very much the question that we have going forward.
Thank you. That was really interesting, and I look forward to some follow-up questions during our Q&A.
So if we're going to start to bow more to shareholders' actual desires, we have to have a better understanding or a better way of dealing with these conflicts of interest among shareholders. So if we're going to start to bow...
Halloween is over. Let's try that again. So Sean, your presentation is titled "Frequent Flyer." Is that right?
Filers, frequent filers.
Frequent
yes,
filers.
Yes.
Now let's sort of frame this a little bit. So you have obviously sort of a long-standing history in sort of talking about sort of shareholder litigation, and so I'm really interested in how you sort of thread that with sort of this board composition conversation we've been having. So maybe you can sort of start off.
Sure.
And,
yes. Sure. And surrendered too easily on the relationship between so I'm not talking about shareholder litigation, but shareholder litigation, of course, is all about the board, because shareholder litigation causes all kinds of incentives for the board to obey or not obey shareholder interests, and can even lead to changes in board composition. How's that?
Great. So, and this is helpful because I think it kind of is a nice segue from Anne's presentation. And so go ahead.
Terrific. Okay. Well, so this, thanks for having me, and it's great to be here. This project is about shareholder litigation, so similar to Ann's in that regard, and in particular, a particular form of shareholder litigation, which is to say, shareholder litigation mostly against class action form shareholder litigation, mostly against M&A transactions. And there have been a lot of studies in recent years about the way and the pathologies that shareholder litigation has developed around this area in particular. And what I wanted to do in this project was look not at the big picture run of cases, but rather at the individual filers, the claimants in these particular cases, in particular the ones that bring repeated such cases, and ask what looking at repeat players in this area can teach us. So one, just the big picture idea is that what's led to this sort of crisis in shareholder litigation is the propensity of shareholders to sue in every merger transaction, and then ultimately to settle those cases out for no monetary relief, but rather for supplemental disclosures in the proxy statement and attorney's fees, of course. Right. So who are the frequent filers? So in this study, I'm looking at 6 individuals who I used just their first initial of their last name, and not a real picture of them, just to protect the guilty. I mean, they might look like that, but I don't know. But these 6 particular plaintiffs have filed over the last 6 years 232 lawsuits, all against corporations, so all shareholder suits. And so my question is, well, looking at this kind of data set and their relationships between each other and between the law firms that they sue with, what can we learn? So here's one thing. Where do they bring their cases, and where do they bring them? So this is a year by year, so going back to 2013, of all the litigation brought by these 6 plaintiffs, and it looks at whether they're bringing their cases in federal or state courts. So the orange is state, the blue is federal. And this is sort of what I expected to see, because in 2016, so you'll see that it's mostly state for the first 3 years, and then it's 50-50 in 2016, and then it's mostly federal for the last 2 years. Well, that's because of a case in Delaware called In Re Trulia, which said that the ability to bring these kinds of cases in state court, in particular in Delaware, would be more difficult for plaintiffs. They wouldn't be able to settle for simple proxy disclosures unless those disclosures were clearly material, and Delaware clearly signaling that they didn't want these cases anymore. Lucky for the plaintiffs, though, that there is a mirror image claim that they could bring under federal law. So the claims had been brought under state corporate law, citing, first of all, Revlon-type claims, defects in the process and the price of the merger, but then appending, once the proxy statement came out, defective disclosure claims. And then the pattern in state court was to settle not on the substantive Revlon-type case, but rather on the disclosure case. The mirror image claim that you can bring in federal court is under 14A of the federal proxy rules, which requires, just as a matter of federal law, that all disclosures in the proxy statement be, fully accurate and without omission. And so their ability of plaintiffs to bring these types of cases in federal court was an important one once Delaware said we don't want them anymore. And we see that in the data set starting in 2016. What types of cases are these people bringing? So this is in reverse chronological order, just because I'm not really good at Excel. But if you look down in 2013, and also the reason that there aren't many observations, I should add, in 2013 and 2014 is that that's the period when they're mostly state law cases. And I got the cases off of Bloomberg Law, which captures dockets. But Bloomberg Law is good on federal dockets, and it's bad on state dockets, because the federal reporting system in PACER is very good, and state court docket reporting systems vary in quality state by state. So it's not that there weren't many cases in 2013, it's just that I can't see them. But what are these cases about? Well, as we would anticipate, they're merger cases. So derivative suits are the orange ones. And then other, which is just kind of random stuff, are the yellow ones. The vast majority of these cases are merger cases, and that's consistent. That's a consistent pattern. But something that's interesting on these, which I discovered and wouldn't have found without looking at the repeat play plaintiffs, is that once they got into federal court, in 2016, they started bringing an additional kind of case as well, and that's the gray shaded area, which are federal proxy cases about compensation. So under Schedule 14A, Item 10A1 says that every year when companies file their proxy statements, they have to disclose things about executive compensation, including the material features of the compensation plan. And that's all that the schedule says. So, well, why is that important? Well, because the proxy rules also say you have to file material information about mergers. So once the plaintiffs were in federal court, they're like, hang on a second. We don't have to just bring merger cases. We can also bring proxy statement cases. And we can settle these out in exactly the same way that we settle out the merger cases, which is to say, file on every proxy disclosure, and then settle for non-pecuniary relief, supplemental disclosures about compensation, and get plaintiff's fees. And that's what we see them doing. So who are these people and what's their relationship to their law firms? What I expected to find was basically law firm ownership of plaintiffs. And that's what I found sometimes. So for example, Stephen B. Brought all of his lawsuits, 42 out of 43, through a firm called Weiss Law. And there was often another firm involved, but that firm was involved almost all the time. Another plaintiff, Paul P., same story with a different law firm. 57 out of 59 of his cases involved Rogodzky and Long. Natalie G., all of her cases involved Faruqi and Faruqi. But that's not true for all 6. So for example, for Matthew S., he brought 2/3 of his cases using Rogodzky and Long, but the other third of his cases did not use Rogodzky and Long, and used a collection of other firms that bring these type of cases. Which suggests some kind of trading relationship by these law firms where for some reason the other firm is going to bring the lawsuit, but maybe, I don't know, maybe the relationship with the plaintiff is run through another law firm, and so there's some kind of opportunity to use that plaintiff in order to bring the litigation. Same story with John S. 14 different firms brought his 18 cases. The most frequently listed firm only brought 4 of them. And also true for Shiva S. She had 89 suits, the most by far of any of the people in this study, and she used 32 different law firm combinations to bring those suits. Several of the firms were listed most frequently, and there's actually a couple of slides from now I'm going to show you a pattern there too. One thing that was interesting to me though is once they started bringing these proxy suits, so once they're in federal court, bringing the proxy suits about M&A, once I saw this in the data, I was like, hang on a second, this is great. There's a story here about innovation and learning in the plaintiff's bar. Somehow once they get into federal court, they're like, now I can bring all kinds of federal court type cases. So yeah, innovation, right? Destructive innovation. The opportunity to learn here. So, who's doing this? Was one question that I had. So once I had these observations in the data set, who's bringing these cases? And it's only Shiva S. Whoops, that's her actual name. All of the proxy cases about compensation except one were brought by this one plaintiff. And of her 32 compensation cases, all but 3 were brought by these 2 law firms. And it's not 2 law firms, actually, it's 1 lawyer who switched firms halfway between my data collection set, right? So this one guy is bringing all of these compensation cases for Shiva S. But interestingly, he and the law firm that he's a part of is mostly not bringing her merger cases. So she's bringing both compensation cases and merger cases in these cases, and they're different. And so what this suggests is like some kind of specialization in the plaintiff bar, where there's an ownership of a particular type of case and a particular claimant, and that person has the privilege of bringing that claimant's cases under this type of claim, but other people can bring her cases under other stuff, which is just an interesting and strange relationship. It's not that these 2 firms, or this one person, actually controls all compensation cases that there are, because there are plenty of other compensation cases under 14A that are not brought by these 6 plaintiffs. And they're brought by, and there are repeat play firms for this too, who are not involved with these 6 plaintiffs. But the question that it raises is, why doesn't everybody do it, right? So if Shiva S can bring these compensation cases once and basically make money settling these cases out in the same way that they settle out merger cases, well, why doesn't Stephen B and Matt S, why don't they all also do it? And they don't. Which is strange, which suggests maybe there's like an honor system among the plaintiffs' lawyers to not disturb each other's business patterns. There are some important differences in the proxy cases from the merger cases. The proxy cases probably have less holdup value than the merger cases, because with the merger cases always have the threat of getting an injunction to hold up the deal. Proxy cases, when I say proxy, I mean the compensation. The compensation cases don't seem to have that same threat. So there's that. So what other patterns can we see? Well, they're also pleading these cases strategically to avoid the Private Securities Litigation Reform Act, which is a federal act that applies to all securities litigation. Once they start bringing these cases, which are really actually, as I mentioned at the beginning, state law merger cases, as federal proxy cases, they're subject to the law about federal securities class actions. And so what do? They're increasingly bring them as voluntary dismissals rather than settlements. The typical pattern for these cases would be to settle out the class action for non-pecuniary relief, entitling the lawyer to a fee. But there's an alternative route to that, which is to just get the non-pecuniary relief, which is to say get the supplemental disclosure, and then voluntarily dismiss the claim and get a fee for mootness, right? The claim gets dismissed for being moot because the thing that you asked for you got, but you're entitled to a fee for that as a result of the corporate benefit doctrine. And that's what they do. Why do they do it? Well, one reason might be because the PSLRA says this. It says total attorney's fees and expenses awarded by the court to counsel for plaintiff's class actions may not exceed a reasonable percentage of any damages and prejudgment interest actually paid to the class. Now, in my side life, I sometimes object to these class actions, and when I'm in federal court, I say, look what the PSLRA says. It says that you cannot award attorney's fees in excess of the damages paid to the class. Well, when there's non-pecuniary relief paid to the class, Your Honor, what are the damages? They're zero. So that means you cannot award plaintiff's fees. And sometimes that argument's rejected, and sometimes it's not. So it's risky, though, to try to ask for fees in settlement, so they don't. Instead, they go the mootness fee route. The other reason is that, and the other pattern that we see in these cases is that they started out as class actions in state court, they move into federal court in voluntary dismissal actions, and they also move into individual actions rather than class actions. And again, I think the reason is probably the PSLRA. The PSLRA says that when plaintiffs file a class action in federal court, they have to provide a list. Is a mandatory term of the PSLRA. They have to provide a list of representative litigation that they've been a part of in the last 3 years. There's also a term that says lead plaintiffs, when they get certified, when the class gets certified, cannot have been a plaintiff in more than 5 representative actions in the last 3 years. Well, Shiva S has done 32. Right? That's just the proxy cases. So she would not be a good candidate for lead plaintiff status if the class were to get certified, so she doesn't ask for class certification. She brings it as an individual action. I guess the threat would be that she could ask for class certification if the defendants didn't play ball. The defendants play ball, and they avoid the PSLRA entirely. Also, when they forgot to do this, or before they started doing this, before they started filing as individual actions, it wasn't unusual for the plaintiffs in these cases not to list all of their prior representative actions in the last 3 years. In other words, just to disregard the provision of the PSLRA that says list them all. And that won't surprise Todd, who's found that the PSLRA is disregarded even by judges. And the bottom line is that plaintiffs lawyers are able to collect fees for these cases still, even though Delaware said, we don't want this anymore. So what should we do? To stop this kind of nuisance litigation. I've written before that the most promising solution might be something that companies could do on their own, which would just be to adopt a bylaw or a charter provision says we will not pay for non-pecuniary relief in shareholder class actions or shareholder litigation. And there's a form of this bylaw that's going around. The trouble is that companies don't like to do this. Nobody wants to be the first mover to adopt this because that will attract litigation, right? So the first time that the first set of companies that are going to adopt a no pay bylaw are going to be subject to litigation by plaintiffs in exactly these types of cases who are saying take off the no pay bylaw, and if they don't do it, and then they basically do it. So maybe the SEC can save us. Can Hester save us? And it's possible that Hester can save us through rulemaking, actually. So one of the problems with the compensation plan disclosures is just the existence of that word material. Other required SEC disclosures, including in 14A, are bullet point specific pieces of information that have to be disclosed. If the SEC, just in its own guidance and rulemaking capacity, just told us what the bullets are that we have to disclose about the plans, instead of saying everything material about the plan, it wouldn't be so easy to bring these cases. The other solution, obviously, would be for Congress to do something like by amending the PSLRA not to allow certain forms of private rights of action, but that doesn't seem likely. Thanks.
Well, let's work backwards. And the first thing I was thinking of as I was listening to you speak, Sean, I'm wondering about the ways in which the litigation you're describing shapes the behavior of the board. I mean, as recipients of this constant, it's sort of seasonal, if you will, incoming fire, how do you think that alters some of the choices they make from a managerial perspective?
So I think the problem with this form of litigation that I'm describing is that it alters corporate conduct not at all. Because everyone understands on the defense side that all you have to do is get out your checkbook and write a $500,000 check, and the lawsuit goes away. And it reduces the incentives on both sides to take anything seriously.
Can I ask one quick factual question?
Yep.
So I understand your data better. The Shiva S, she gets some money?
I don't know. I don't think so. Maybe not. I mean, so it's not from the company directly.
So oh, I see. But it would be illegal for the law firm to pay her?
Probably. I don't know. Actually, I believe so.
So what's her incentive?
Yeah. I mean, I object to these class actions for Ted Frank because I think that they're horrible and it's a public service for me to say, right. I bought Rice Krispies and so I'll object. But
why does she do it?
Why does she do it? Is she really just like because it's. There I'm trying to achieve what I believe might be perverted social good. Mm-hmm. Here, nobody believes this is a social good. These lawyers don't even believe it. They just are shaking them down. So what in the world are their motivations?
So that was going to be my next question. It's sort of like, where does No, it's fine. Steal away. But no, it's like I think we're all moving in the same direction, which is like.
Because that would be because I'm practicing it, but I just don't remember. I mean, obviously there are certain. If I wonder if that's a function that the voluntary dismissal is serving, because normally either there would be a prohibition on paying them anything other than their reasonable expenses. Well, first of all, what you can reimburse a class plaintiff for. If they're individual, that's another thing with the individual. Like none of those obligations about what they're being paid for. Like normally there'd either be disclosure obligations or you could pay them for their reasonable expenses in being a plaintiff in a class. They're allowed to receive that. They have to travel, if they go to deposition, but if it's an individual plaintiff and it's a voluntary dismissal, they may be avoiding whatever rules exist about either disclosure or just no kickbacks at all.
So the answer is I don't know if they're getting paid. They might be. They're not supposed to get paid for settling a class action. You can ask in Delaware for an incentive fee, which sometimes people ask for, but it's very rare, and it's not very much. I mean, it's much, 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 much less than the attorney's fees when it is awarded. So it's very unclear what's going on here.
Can I ask?
Sure. Go ahead.
So I really love the point about corporate governance that you made at the very end about incentives. So I've said this before in a different context that there's this issue about the first mover bears all the cost. Mm-hmm. And because we can't get intellectual property rights in corporate governance, then you don't have the, because that's a way of giving people who are first movers some advantage. But the minute you have some corporate governance provision that you adopt some bylaw and it gets, you win at the Delaware Supreme Court, everybody will do it immediately. So that's why something like Delaware's 102b7 self-indemnification rule, like once they promulgated and said you may do this, every firm adopted it. So there was like this huge latent demand for corporate governance innovation. So I think that's a really important point and something we don't have a good solution to. I think my board idea of firms might be a little bit. One question about these cases, you mentioned the study I did with William Hubbard about the PLSRA and Rule 11 sanctions. Is the voluntary dismissal covered by 21D?
I don't.
One so the rule is that the district court in securities suits is required to make Rule 11 findings. My study says they don't do it because nobody brings it up. But it would be if you brought it up and said even a voluntary dismissal, that's a final adjudication because it's doing away with the case, and there are mandatory Rule 11 sanctions. That's another arrow these companies could use and say, like, we want to have this was harassing.
Yeah, I'll check.
Yeah.
Ann, I was going to pivot towards you a little bit and ask you, one of the things that struck me in your presentation was this discussion about the tension between, board members who feel trapped between this sort of wealth maximization paradigm and obedience to shareholder expectations. Does that sort of freeze them in a certain way and make them reluctant to, does it have a chilling effect in terms of creativity or sort of a sense of independence with regard to how they make choices inside the boardroom? What are your thoughts about that?
I honestly don't know reality. Certainly they say it does. I mean, one of the big arguments that's going on right now is that board members feel that, once again, it's not necessarily going to be a litigation issue because, they're protected in a lot of ways, but a lot of boards feel that, trends towards either like these powerful shareholders who have access to the corporate proxy, who have, pay and stock options, who have many more tools at their disposal to force directors to behave as they want to, that this is, boards and management are arguing, of course, that this takes away from their ability to engage in long-term wealth maximization, which is bad not just for the shareholders, but it's also bad to the economy in general, because the basic argument is, hey, if we have to do short-term because a hedge fund wants it, then that means we won't invest in R&D. So certainly boards will say that that they would rather, that the shareholder demands are short-sighted and uninformed, and that therefore they should essentially not be as beholden. That's why there's a movement by some boards now to not have quarterly earnings reports anymore, to only report every 6 months. Now, whether that, and it's why we have more of a move toward dual-class stock ownership in IPOs. Whether that is in fact the case, though, is a whole separate question. Of course, boards don't want to be monitored by shareholders, but whether that's because they're actually not going to innovate otherwise is a really different sort of question. And there are certainly plenty of evidence that, like, there's evidence both ways about whether R&D spending gets reduced when shareholders have more power, whether it doesn't get reduced when shareholders have more power. So it's really like, of course they're going to say it, but whether it really is true as opposed to just we don't want to be disciplined is another question.
A related question about, go ahead.
Just one quick comment. Sure. I love the presentation about this case, and I share your view that it was sort of ridiculous. This idea that board members would be, and there's all this law about, are they conflicted or interested or not, is all just a farce. It's like the fact that I'm going to keep my board seat or not, if we do this merger, is not considered a conflict. It can't be considered a conflict, because if it were a conflict, you couldn't have a board member decide the case. Well, of course it's a conflict. It's an enormous conflict. So, and this idea that these board members are conflicted because they were put there by these activists is crazy. That was the whole point of them going there. Again, if we, there's all this Delaware law about board members that is completely derived from the fact that these people are treated as individuals, which I think is a mistake. I think if you had a board that was just like, this firm is our board, they get to decide, all this Delaware case law, which is just silly, all goes away.
Okay, so I'm going to pivot to that, because my question to you is, given what you envision as the role these firms might play in a corporate governance context, do you imagine or contemplate that they themselves should be structured in a particular way, given their function? In other words, who governs the governors?
Yeah. So it's a great question, and it's the Dr. Seuss bee watcher problem.
Right.
That there was the bee who was supposed to get the honey from the flower didn't do his job, so they hired a bee watcher, and she watched him. But then who was watching the bee watcher, and it goes on forever. So the first point I'll make is I'm an academic, so I don't know anything. And if you said to me, how should this board service provider, that's what we call them, a BSP, how should they be structured? If I had answers to these kinds of questions, I wouldn't be an academic. I'd be out there building companies and doing real stuff, so I have no idea. It could be the case that the board service provider, boards are us, they have a kind of shadow board that has 12 people on it, just like the regular board, and they meet and decide stuff, and then they vote, and whatever the consensus is, that's the decision of the entity that they're part of. I'm imagining an enormous back office for these people, because right now, if you want to put, there's a senator who was a senator from a very small New England state, and she lost, and a big industrial company in Illinois just put her on the board. Why is she on the board? Why is Chelsea Clinton on Barry Diller's board? Not because they know anything about cybersecurity or strategy or crisis management or finance or anything else. They're there for political reasons. Well, okay, that's fine. If you need to have a former senator on your board to play the game in Washington, that's well enough. But they don't know anything about the substance of stuff they're going to be called on to ask. One of the virtues of the board service firm is, instead of having to buy expertise, this board member has to buy expertise about consulting or cybersecurity from some firm in the market. They just have it on fiat. They can just walk down the hall and say, hey, we're voting on the CEO's pay package. Tell me everything I need to know about executive compensation in the next couple of hours.
Okay,
so that I think is no, I totally avoided your question. But the question about who would govern these boards, so I don't know what the insides look like of these firms. Who would govern them? Well, the market would govern them in the sense that firms that did a good job governing companies would succeed, and ones that did a bad job would be ground under by the market. I'm imagining some of these firms could be publicly traded, so they would have public shareholders themselves. And so it would be a market for corporate governance, and the disciplining of them would come from a variety of market forces as opposed to the current system, which is not a lot of discipline. There were 17,000 board member elections in the United States last year, and 6 people were ousted.
Okay, so a related concept that comes to mind as I listen to you speak is just sort of like a bond rating agency, right? So, you wonder if Moody's or one of those folks starts to
I wonder why you picked that example.
Right. Slides into this space and subsequently gives bad advice.
Yeah. So so it's a great observation and a good one to throw at people, because that was a clear failure. But like most markets that fail, the problem was government and regulation and how that system evolved. So, the fact that there were bond rating agencies was derived from state law requirements that things like insurance companies could only invest in things if they were AAA rated. Insurance companies have inverted production functions, and so they need to have special government regulation. So you set up this thing that says your insurance company you can't invest unless it's AAA. Well, what's AAA? Well, what we should do is have these firms decide, and here's our holy water. This is AAA. And of course, then the SEC basically encourages a duopoly among these two firms, and it really wasn't a vibrant market. So yes, there can be problems. I'm not saying markets are perfect, but we have to compare the model that I'm proposing not against nirvana, but against the next best alternative, which is what we have now, where there's effectively zero market discipline on board members as board members. There's plenty of market discipline against firms, not against board members as board members.
I have a question, because I'm aware of your book, but I hadn't read it. I apologize. So you may cover this in the book itself. But my question is, if companies were the board members, would a trade-off be something like getting rid of 102b7 or indemnification provisions, make them actually liable for actual governance failures?
Yeah, so I think it's a great question, and one of the surprising things that we came to, because I'm pretty hostile to the current set of litigation for the reason Sean and others. I think one of the upsides of this is there might be more aggressive policing of fiduciary duties on substance, because one of the things that Delaware courts have, I think, evolved into is not holding directors personally liable because they're bankrupting individuals. If you just consider the difference between Smith versus Van Gorkum and the Disney case involving Mike Eisner and Ovitz, the Delaware Supreme Court says in the Ovitz case, well, Sidney Poitier, I'm really sorry that you did such a terrible job. Shame on you, Sidney Poitier. But we, the Delaware Supreme Court, are not going to bankrupt Sidney Poitier. He's an American hero. Did you see in the heat of the night? We're not going to do it. And so it's sort of like shame, 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 do better, hoping that has some effect. Well, if firms were providing that governance, firms can share risk a lot better than individuals. So I think there might actually be more aggressive policing by Delaware courts because they wouldn't be so worried about individuals because of the risk spreading function. Also, because of the risk spreading function, just last point, I think you'd get more innovation. I think a firm that was a board service provider would be willing to bear the risk of being the first mover because it might see the advantage of getting a brand of being the first mover in corporate governance. So if Boards R Us innovates in the way Sean says, does that bylaw, and they say, well, that was really great, I might hire Boards R Us to be my board in another company just because they've got this brand for being really good governance people.
And also they can benefit from the innovation across companies as opposed to just one.
I have a lot of questions, but I think we've got to open things up to our audience. So I thought we should do that. We've got, how much time have we got left?
A little bit less than 10 minutes.
Okay, so just under 10 minutes. So let's do that. Is there a microphone? Okay.
I have a really dumb question for Professor Henderson. Suppose we have Boards R Us. How are we going to decide whether Boards R Us is doing a good job any more than Tobin's Q or any other research mechanism?
Great.
And I ask this question because I know nothing about this subject.
What's the metric?
Good. So yeah, you know just this much less than me. It's a great question. So the value of anything is the price it will fetch. So I'm not one of these people like Thomas Aquinas who thought like there's a just price and we can figure out what the value of something is. So I have no idea. The value of corporate governance will be determined by people who are choosing whether or not to hire Boards R Us or somebody else to be their board. So presumably if, imagine a case in which Boards R Us is publicly traded. We'll have millions of people who are making an assessment of the value of Boards R Us, and their stock price will reflect something like the value they're providing, just like Apple's stock price reflects the value of Apple. When Boards R Us is hired, when the shareholders, let's imagine a situation where the shareholders are, by bylaw, required to be presented with two board companies, and they get to vote on which one is going to be the board company. Presumably, when they have that vote, and Boards R Us is nominated to be the board of XYZ company, the stock price of XYZ company will change on that day. People say, hey, we think Boards R Us is really great. They won. Therefore, XYZ will be worth more. The stock price of XYZ should reflect that. We don't get these kinds of market experiments where people, investors betting their own money, are making assessments because that's not how it operates in the current environment. If I'd gotten one of those board seats, it would have just been announced in an 8K, and what effect am I going to have on a board of 12 people? So we don't get the market adjustment. So the answer is the market will tell us. Will the market always get it right? Well, of course not, but it's better than the current system, which is we have no idea.
I suppose that raises another question about whether the market of, the capital market is any more or less a sort of a metric space than, say, the community of academics and experts who opine on these things.
The big difference is when the market gets it wrong and people who are betting their own money make a judgment and they say, we think Boards R Us is really great, and it turns out they're terrible. those people go out of business and they learn from those mistakes. Like I said at the beginning of my remarks,
you keep
if I'm
tenure.
wrong, like I have tenure, and just look at political prognosticators, people who say, oh, the stock market's going to collapse when Trump is elected president and jobs are going to flee, whatever. I mean, we heard all these things. Of course, none of it is true. Trump's got his own, problems and issues, and I'm not defending those. But those prognosticators were flat wrong. Those people are still on CNBC prognosticating about what the future's going to be. Like, why should we listen to you? You were completely wrong about the effect of Trump on the economy, at least for the first 2 years.
Okay, we have 5 minutes remaining, and we have a couple of some hands up.
Sorry,
Jessica?
one more question for Professor Henderson. So how would board service providers deal with inside directors? Would there be no inside directors? And if that is the case, wouldn't that be a loss on the boards to have that inside information?
Yeah, so that's a great question. So in the model of a board service provider, this imagines no inside directors. This means that firm information is conveyed to the board service provider and that insiders don't have votes on the board. So that's right. Presumably, if there's value in these in that kind of information going to boards, board service providers would try to innovate in ways that would address this problem. But I think it's a real limitation, one we talk about in the book, but it's a really good observation.
We have time for one question.
So my question is, basically, do you anticipate that these board service providers would react differently than a board composed of individual members to these pressures that we're talking about, specifically the conundrum of how responsive are you to the actual shareholder desires versus minority shareholder rights versus just profit maximization? Would they react differently because it might be easier for shareholders to say, fire the company and hire a new one than to oust all of the individual members?
Yeah, it's a great question, and I love Dan's presentation. I think that she's hitting on a really important topic that academics are going to have to wrestle a lot more with. So one thing we talk about in the book is our proposal is non-ideological in the business law sense. So if you imagine there's the Lucian Bebchucks of the world who are in favor of a lot more shareholder power, access to the proxy and such, and then there's the guys at Wachtell Lipton who are in favor of more managerial power. If you just imagine that's the sort of spectrum, our proposal could be used by either of them. So you could have shareholders have more access to the proxy. That is, they're allowed to every year nominate a board service provider to replace the current board, either of individuals or of a BSP. Or you could imagine, as Marty Lipton and Steve Rosenblum have written about, a very underappreciated article in my opinion, from I think 99, that we should have board elections every 5 years. We pick a president for 4 years for a reason. It's not 20 years, because that's too long term. It's not 2 years, because that's too short term. So the founder said, let's have elections every 4 years. And in this paper, Lipton and Rosenblum say, maybe we should have director elections every 5 years. You pick a board for 5 years. There's no litigation. None of the Sean stuff, none of this short term, whatever. 5 years after, there's a real election in which the shareholders get a choice. You could do this with a BSP. You pick the board service provider. Every 4 years, it's like rotating auditors. You have a new election, and the firm gets to choose whether to stay with that BSP or pick a different one. And in that short period, the concerns that Ann's talking about sort of go away. The concerns that Sean's talking about go away. We don't have any of that corporate litigation, and we let the market decide during those 4 years. That's another alternative, and our model fits with that as well.
This has been a wonderful session, and I want to thank each of our three panelists, Todd, Ann, and John, for their contributions today. And we're going to break and start our next panel shortly. Thank you very much.